So let's see. Constructive possession of a firearm. Constructive, again, I've said this before, just means fake. Anytime you see it in the law, just anytime you see constructive, just think fake. Constructive possession, constructive trust. Can't think of more right now because I'm on the spot. For those who are entrusted with firearm prosecution, a defendant need not have actual possession of a firearm in order to be liable for possession of a firearm during the commission of a felony or possession of a firearm by a convicted felon charge. Whew. That's a sentence. For those who are entrusted with firearm prosecutions, comma, a defendant need not have actual possession of a firearm in order to be liable for possession of a firearm during the commission of a felony. That's 1611-106, or possession of a firearm by a convicted felon charge. That's 131. Funny thing, I haven't thought about this before. It's just, I'm smarter than they are. Constructive possession doesn't even fucking apply to possession of a firearm during the commission of a felony. That's 1611-106. It's not a possession standard. It is on or within arm's reach, unlike 1611-131. And I'm going to show you guys that I'm right. So that's a really bad start. Let's see here. Georgia Code 1611. This is 131. This one does actually use the possession standard. 1611-131B. Receiving, possessing, or transporting a firearm. Receive, possesses, or transport a firearm. So possession applies to 1611-131. 1611-106 this is also for 133. It says, any person who shall have on or within arm's reach of his or her person a firearm or a knife having a blade of 3 or more inches. So yeah, it's not possession at all. He's completely wrong. He has no idea what he's talking about. But we already knew that because fucking not going to finish that sentence. Yeah, so he's completely wrong. He got through almost the first sentence before messing up. So good job. I'm going to fix this. A defendant need not have actual possession of a firearm in order to be liable for possession of a firearm by a convicted felon. Get rid of that too. Constructive possession. It's not a... Push P real quick. There we go. Constructive possession applies when the defendant knowingly has both the power and the intention at a given time to exercise dominion or control over a thing, and it must be based on some connection between the defendant and the contraband other than spatial proximity. It means being close is never... Mere proximity is never sufficient to establish constructive possession. This means that we can't say the defendant was in the mere presence of a gun, but that they had the ability to exercise control over it in some way, shape, or form. That's also wrong, by the way. Both the power and the intention at a given time is fucking right that you just quoted it 4 lines before. 5 lines? 1, 2, 3, 4. 4 lines before. You just fucking quoted it. How are you fucking it up already? You just fucking said it. It's right there. It's on the same page. It's not even multiple pages. It's 1 paragraph. You had a month to write 1 fucking paragraph and you couldn't even get it right. You got the law wrong. You got the common law wrong. Or the case law wrong. It's right. Even if you know nothing about the law. You just quoted it. It's right there. This essentially means that we simply can't say the defendant was in the mere presence of a gun, but that they had the ability to exercise control over it in some way, shape, or form. It's you. You had months. You had a month to write this, and you already fucked it up repeatedly. This is the middle of the YSL case. You already had to dismiss the one charge. We're looking at Miles Farley after this. If the defendant is party to a crime or a co-conspirator to other individuals who are in possession of a firearm, then the fact that they are an active participant in effectuating the crime while can make them liable for possession of a firearm-related charges. So this is one of the dumbest things I've ever read, but it relates back directly to what we just talked about. I hope nobody's watching this or is gonna see this online at any point. I have nothing but the utmost respect for the Fulton County District Attorney's Office and the attorneys that work for them. Talented individuals. Okay, so this is the arrest warrant for Mr. Slato, Miles Farley. Keeping in mind what we just said about possession and mere proximity not being sufficient to establish possession, constructive possession. Personally came D.D.S. Taylor, who on oath says that to the best of his knowledge. Is it a D? Or I think it's a he. Can't remember. I looked it up at one point. Best of his knowledge and belief, Miles Malik Farley, between 3/6/25 at 5 and 6 at Old Hateful Road, did commit the offense of possession of a firearm by a first offender probationer, that's 131. In that capital said accused did have in his possession/wingspan, those are two different things, a Glock 17 while being a passenger in a black sedan during a traffic stop. Mr. Farley is on first offender probationer for violating the RICO Act on 12/17/24. That's completely incorrect. That is not when he violated, he didn't violate it, but that was when he was convicted. That's just not the date of the violation. Not that he violated it, but I'm not going to make fun of this. Tracking number, blah, blah, blah. Said in this deponent makes this affidavit that a warrant may issue for his/her arrest. Probable cause. On March 6, 2025, I, Officer D.S. Taylor, Unit 1851, along with other Apex units. What is an Apex unit? I don't know. I bet that doesn't matter at all, though. Conducted a traffic stop at 2865 Old Hateful Road on a black sedan bearing a Georgia tag of YXN504 for the violation of 4873-1. That's not the right code section. I think I shared this with Tiffany. 40-8-73.1, not 4873.1. Okay, so this isn't a law at all. Not that it's a big deal. I exited my patrol vehicle and approached the passenger door to make contact with the driver and the passenger in the vehicle. Upon speaking to the driver, I noticed both individuals were not wearing their seatbelts. I identified myself as a City of Atlanta police officer, requested their ID, and advised the driver of the reason for the stop. Skip this. This might be my favorite sentence I've ever read. During my investigation, I saw what appeared to be marijuana flakes, which is apparently a brand name, on the center console and on the floorboard of the vehicle based on my training, knowledge, and experience. Marijuana flakes. I should make that into a thumbnail. Like a Wheaties box, but make it anyway. I then asked if there were any narcotics or firearms in the car. You see the weed on the... Both individuals answered no. Based on the information that I gathered, I requested both males to step out of the vehicle so that I could conduct a further investigation on the matter. I have no idea what that means. At the same time, speaking of the males, I had officers request K9 to my location. After conducting the open air sniff, K9 Jumbo positively alerted the driver's side door of the vehicle. I then walked over to the driver and advised him on the next step, which was a search of the vehicle based on probable cause. You didn't have probable cause when you saw all the weed just askew, just everywhere, just piles of weed just on the center console and the floorboards. That wasn't probable cause, just actually seeing the marijuana. But then Jumbo shows up, alerted on the driver's side door. Yeah, there you go. That's probable cause. While searching the vehicle, I recovered a Glock 17 inside the glove compartment on the passenger side of the car. So, what did he find? He found a Glock 17 inside the glove compartment on the passenger side of the car. That's what he's found. I also recovered a white pill with the markings T194 next to the passenger door. I did a Google search on the pill identifier and determined that the pill was oxycodone. Both males were then detained by placing capital city handcuffs on them. That's kind of funny. I don't know why he did it that way. There we go. I asked both males who the firearm belonged to. While they were in handcuffs. They both stated that they did not know that it was in the vehicle. I conducted a if any of you guys say that's not custodial interrogation, I'm banning you. They both stated that they did not know that it was in the vehicle. I conducted a criminal history inquiry and a status check on both the males and the firearm. The firearm came back not on file, while the criminal history revealed that Mr. Miles Farley is on the First Offender Act out of Fulton County Superior Court, violating the RICO Act. I read Mr. Farley's Miranda rights, and he agreed to speak with me without his attorney present. I asked him about the firearm, and he denied knowing anything about it or being involved with any gun. The driver later stated that he would take ownership of the firearm if I let Mr. Farley free, which indicates to me that they both knew that the gun was inside the vehicle before the traffic stop. Mr. Farley was placed into custody. You had him in fucking handcuffs. You took him out of the car and put him in handcuffs. He's already in custody. You don't get to decide when custody starts. That's not a thing that police decide. Mr. Farley was placed into custody and charged with 1611-131B, possession of a firearm by a first offender probationer. So let's look at this quote that they themselves, not you, they used here. So, constructive, these aren't my words. I just want to reiterate that. Constructive possession applies when we can present direct or circumstantial evidence support that the defendant knowingly has both the power and the intention at a given time to exercise dominion or control over a thing. It must be based upon some connection between the defendant and the contraband other than spatial proximity, mere spatial proximity. So this is their own guy. He might even be a lawyer. I doubt it, but so what do they say? The driver later stated that he would take ownership of the firearm if I let Mr. Farley free, which indicates to me that they both knew that the gun was inside the vehicle before the traffic stop. That doesn't make any sense, but ignoring that Farley knowing the gun was in the glove compartment still wouldn't be sufficient. It's still not possession, constructive possession. Even if he knows it's there, he doesn't necessarily have the intent to exercise control over the firearm. This warrant's defective. I hate you. Not you, but these people. Oh, actually, I want to show you guys one thing. I'm kind of petty. I don't know if you guys know this. That's right, Wendy. Sometimes I'm petty, and I get obsessed with stuff. So I actually wanted to know whether these dogs could detect pills. Because remember, the only drug that was found was a single oxycodone. So I was thinking, I don't know, maybe these dogs can detect pills. So I actually sent a Freedom of Information Act request to the Atlanta Police Department for the dog's qualifications. Because I'm normal and I have a full life. So I FOIA'd the dog's records. I didn't ask about Chloe. And you'll see, is this Banshee or is this the other one? This is Banshee. No, we need Jumbo, not Banshee. Here we go. Officer Pagan. Yeah, not Basile. This is Officer Pagan, K9 Jumbo. These are his records. Let's see. These are the drugs that he was trained to detect at the time. You'll see he has marijuana. Wait. Marijuana, cocaine, heroin, meth, Papa Molly. I'm sweating on Instagram. Straight flexing. So there's no, the dog wasn't qualified to detect oxycodone. So I have no idea what the dog detected. I mean, the dog didn't detect anything. I'm familiar enough with the Apex unit to know that, but I thought that was funny. And I've been over this stuff before, but I always love talking about this. It's just such a dumb case. So this was filed a couple of days later by Mr. Joseph Storno. And if you're familiar with the YSL case, you might want to go back and look and see if Joseph Storno's name comes up. This was written a day later, I believe, or 2 days later. This was written March 7th, whereas the prior one was written March 6th. So it was written a day later by Joseph Storno. Mr. Johnson. Oh, did I skip Mr. Johnson? I forgot about Mr. Johnson. You're right. Good call. I'm so glad you reminded me of that. So stupid. Okay. The accused unlawfully was employed or associated with the criminal street gang YSL, a local subset of sex money murder. Not really the theory. To conduct or participate in criminal gang activity through the commission of a crime enumerated in paragraph J of OCGA 1615-3. I thought it was paragraph A. Is that even still is that the right code section still? I thought they changed it. Yeah, it's 1J. It's not paragraph J. That's incorrect. That's the least wrong they'll be this entire time. It's paragraph 1J, not J. Specifically, a criminal offense in the state of Georgia that involves violence, possession of a weapon, or use of a weapon. The activity involved the criminal offense of possession of a firearm by a first division probationer, during which Miles Farley was lawfully in possession of a Glock 17 9mm firearm. Mr. Johnson. I wish it was Mr. Jones, because then I could play Mr. Jones, and that'd be fun, but oh well. Mr. Johnson. Mr. Johnson's documented affiliation with YSL, coupled with his presence in a gang-controlled location, while armed, demonstrates his active participation in advancing YSL's criminal objectives. I'm so jealous of Anastasius. I can't express how jealous I am. I feel like I would pay Miles money to get to just argue this in court. I'm so jealous. He dresses Anastasius. He's got the cufflinks. He's got the 3-piece suit. He's got the facial hair. He's looking all fucking fly, and he gets to argue about Mr. Johnson. Such a dick. He's got everything. He's got the cool arrest story. Oh, man. Mr. Johnson's documented affiliation with YSL, coupled with his presence in a gang-controlled location while armed, demonstrates his active participation in advancing YSL's criminal objectives. I wonder what Miles did. Possessing a loaded firearm in furtherance of gang-related activities aligns with YSL's established pattern of using weapons to protect and promote their illicit operations. It's spelled illicit, right? That's good. These actions highlight Mr. Johnson's role in perpetuating gang dominance and securing the gang's operational stronghold. Sorry, dog's being bad again. Yeah, I'm just not going to finish that. Okay, shout out to Aaron for reminding me to read about Mr. Johnson. Mr. Johnson. March 6th, approximately 5'10", the Apex unit, blah, blah, blah. Being terrible. While patrolling the area, Officer D.S. Taylor conducted a traffic stop on a black Ford Mustang bearing Georgia tag YHM 162. Now, I noticed this the first time I read it. This is not the same license plate number. They actually changed the tag number from the first warrant to the second warrant. And I don't know if you want to call a Mustang a sedan, whatever, but it seems like they probably changed the car too. Somebody in my chat last time I talked about this on Tiffany's stream, I think they said the car came back to like an SUV or something. The first tag, and the second one came back to the Mustang. Whatevs. Upon approaching the passenger side, Officer D.S. Taylor observed that neither occupant was wearing a seatbelt. Okay, again, that's not a law. The driver was identified as Joarius Greer, a.k.a. B-Slime, and the passenger as Miles Malik Farley. Funny thing about B-Slime, there are actually two B-Slimes. YNW Melly's brother, what's his name? Brandon? Is it Brandon King? I think his name's Brandon King. Yeah, Brandon King is YNW B-Slime. Joarius Greer is YSL B-Slime. But the funny thing is that Brandon King, Young Thug has a brother. Young Thug and Joarius Greer are related. I think it's his nephew. But Young Thug also has a brother, last name King, Gregory King, who has a case coming up in 2 months from today. So he also has a King in his family, and he's related to a B-Slime. So YNW Melly also has a King in his family who is a B-Slime. And if you go to the Lyrics website, sometimes they mix up the B-Slimes. So that's my fun Joarius Greer fact. Aaron says Miles was not charged with 1615-3. Yeah, I have no idea what they're doing. Has he been charged yet? He was, right? Or did he? He hasn't been indicted, right? I looked like a month ago, but I haven't looked since then. I'm so jealous of Anastasios. Okay. Upon approaching the passenger side, Joarius Greer, passengers Miles Farley. During the interaction, D.S. Taylor observed what appeared to be lowercase marijuana flakes. Lowercase marijuana flakes scattered on the center console and floorboard. Based on training, knowledge, and experience, this raised suspicion of possible narcotics possession. Yes, seeing marijuana just strewn about is suspicion of possible narcotics possession. He's not wrong. Oh my goodness. Okay. Given the presence of suspected marijuana residue, whether residue or flakes, those are different things. The occupant's statements. So the statements thus far are what? Just denying any contraband? That doesn't make any sense. Both individuals were asked to exit the vehicle. A request was also made for a K9 unit to respond to the scene and conduct an open-air sniff. Canon Officer J. Pagan arrived shortly thereafter with Jumbo. Jumbo did nothing wrong. Hey, Trakisha, what's going on? Based on this positive alert, Officer D.S. Taylor advised both occupants that a probable cause search in the vehicle would be conducted. During the search, a Glock 17 was discovered inside the glove compartment. Additional, a white pill with markings T194 was found on the passenger side floor near the door. A pill identifier search, as opposed to a Google search, making it sound all police-like, being all fancy. Lay witness Jumbo. Both individuals were immediately detained. When questioned about the firearm, neither Mr. Greer nor Farley claimed ownership, both stating that they were unaware of its presence inside the vehicle. A criminal history check was conducted on both individuals, along with a status inquiry on the firearm. The firearm was found to be not on file. However, the background check revealed that Mr. Farley, not Mr. Johnson, was currently on first offender probation following the conviction on December 17th. Officer Diaz Taylor read Mr. Farley his Miranda rights. Let's look back at this, actually. Let's see here. So, the first thing that happens, question about the firearm. Read his rights. Where is... you'll see that in the prior version, he puts the handcuffs on him here, then he asks them the question, and then he read the Miranda rights. But in the later version, they changed it to the questioning without mentioning that he was in handcuffs at the time of the questioning. So the second the warrant is makes it sound like there wasn't a Miranda issue. The first one does. So he's trying to fix it. And it says, first one, he's asked for any firearms or subs. Oh, I didn't see that. Interesting. So yeah, they were trying to word their way around an obvious Miranda violation on the second one. When asked about the firearm, Mr. This is so stupid. When asked about the firearm, Mr. Farley denied any knowledge of it or involvement with firearms. However, Mr. Farley was seated in the front passenger seat, directly adjacent to, because they don't know what adjacent means, and within arm's reach of the glove compartment where the firearm is located. Given its close proximity and ease of access, it was determined that Mr. Farley had constructive possession of the firearm. I sure hope there's nothing in their own words that is going to contradict that. Let's go back to their words again. Let's see what they say. Constructive possession applies when we can present... Oh, I want to trick Keisha. This is one of the Fulton County, the district attorney's newsletters. So this is Gautam Rao. He's the DDA training. So this is the head honcho, well, not head honcho, the training guy's words on constructive possession. Constructive possession applies when we can present direct or circumstantial evidence to support the defendant knowingly has both the power and the intention at a given time to exercise dominion or control over a thing. It must be based on some connection between the defendant and the contraband other than spatial proximity. So simply being close is not enough. What does the warrant say? Given its close proximity and ease of access, it was determined that Mr. Farley had constructive possession of the firearm. So A, no. In their own words, they don't have constructive possession. First of all. Second of all, the police don't get to decide whether there's constructive possession. That's a conclusion of law. It's a question of law. It's not a question of fact. It's completely inappropriate that they put that in there. It's ridiculous. Further supporting this conclusion, Mr. Greer later offered to take responsibility for the firearm in exchange for Mr. Farley's release, an action that strongly suggested both individuals were aware of the firearm's presence. Also not enough. As you said back here, knowingly has the power and the intention. Being aware of the firearm is not enough. So again, they still don't have probable cause for the arrest for the. I shouldn't have said that. They still don't have constructive possession.